so that we have at least 15 minutes, 10 or 15 minutes for questions at the end. Alex can introduce himself in a second here, but I will tell you that he's been a very helpful young man to me because he understands technology much more than I do. And so he kind of took the lead on pulling together all the technical aspects of this, and I'm really grateful to him for that. So next slide. As I mentioned, I am the executive director of the Disability Law Center of Virginia. And we have a unique role throughout the Commonwealth of Virginia to protect the legal rights of people with disabilities, of all disabilities, to promote independence and choice and self-determination for people with disabilities. We have a large mandate to investigate and combat abuse and neglect, and to generally promote the rights and the advancement of rights for people with disabilities. And if you are hearing my dog in the background, I apologize for that. Next slide. Alex, go ahead and introduce yourself.
So I wanted to just begin by thanking everyone for watching, and thank you, Colleen. And Colleen definitely does some incredible work at the Disability Law Center of Virginia. So my name is Alex Campbell, and I am a self-advocate. I have autism, and I've been involved with the Restraint Seclusion regulations since, I guess, for the past 6 years, maybe. And I've worked around the state to kind of promote change and really get regulations on something that really need to be, they really need to take place. And through this, I've met a lot of amazing people that are on the screen, including Tanya and Colleen are just, some of the amazing and wonderful people I've met. And I'm really excited to be here. So I was also suspended 35 times in kindergarten and 25 times in first grade, which is actually illegal because I have an IEP. And through this, my case manager kept locking me out of the classroom. And therefore, not only was I being socially separated, but I was not receiving the necessary academics that I needed. And I was also kicked out of school in first grade. And because of that, I was moved to a private day school. And so through all of this, my parents, this was kind of before we met Colleen and the ARC and people, who actually helped. They tried to get help, my parents, from the Director of Special Education and the Director of Community Services Board. And instead of help, they received a letter from both of them that said I was, quote, destined to go to jail, end quote, when I was 6 years old. And in addition to that, the Director of Special Education tried to get a court order to put me in an institution. She was unsuccessful, but she definitely spent thousands of dollars in legal fees trying to do it. So then I was put in an outside placement in second grade. And unfortunately, it was actually worse at this outside placement. And my principal locked me in a room called the crisis room on a daily basis. And it was a seclusion cell. There were walls painted black, no lights. He had a desk in front of the door, and there was like a barbed wire window. And so it was not pleasant. And then in addition to that, he told me that if I told my parents, he would put me in there every day. So it was a while before I eventually told my parents. And so after that, I went to another school I mean, this was several schools later, in which I was, a teacher took her nails and grabbed me by the neck and slammed me to the floor. But because the school claimed that she was not properly trained, they got away with it because that's how the situation was in Virginia. There were absolutely no laws. And in fact, what the school did is they took this teacher and they moved her to a nonverbal classroom so she could continue the same behavior on kids who can't speak up. And unfortunately, with this school, you know, they're owned by a very wealthy family, and they unfortunately operate as a corporation. And to this day, we're still harassed by this corporation, you know, and they're some very, you know, just not nice people. They recently threatened to sue Columbia University and USA Today, in addition to us. And so, I mean, they're really, you know, have that corporation mentality of they're going to sue anybody who speaks out against them. This is you, Colleen.
Okay, thanks. Thanks. So just that one for right now. So no,
Okay.
the countless stories like Alex's, and go ahead, pop up the next one. The Disability Law Center at this time was known as the Virginia Office for Protection and Advocacy, VOPA. And we were unfortunately hearing just numerous stories from parents and family members similar to Alex's, and really outrageous conditions that children were being placed in. Some of you might also remember that at a private school in Virginia, there was a death of a child in restraints. And unfortunately, that restraint was not like the one pictured on this slide. That restraint was, the young man was placed on the ground and everybody piled on top of him until he stopped breathing. And so that was an effective restraint. Next bullet. The disability, VOPA at that time, and a number of other organizations worked through the state Special Education Advisory Council to try to get some regulations to limit the use of seclusion and restraint. And in 2009, the Department of Education issued what they called guidelines. They were just, you know, suggestions. They were not, they were not really anything that anybody had to follow. Next slide. Next line. As a result of stories like Alex's and the deaths we were hearing about, and the really kind of outrageous conduct by some individual school districts, a group of organizations came together in 2013 and 2014 called the Coalition for Improvement to Student Safety. And this group began to put together a position paper outlining some recommendations for what the state needed to do about this. And the ARC of Virginia was a part of it. The Stop Child Abuse Now organization, VOPA, the Virginia Board for People with Disabilities, the Partnership for People with Disabilities, a number of small organizations and some individuals. It was a pretty comprehensive coalition. Next bullet. Around that same time, as a result of the kinds of cases that we were representing, the Disability Law Center did a statewide survey of school districts' practices regarding seclusion and restraint, and we put together a report called Unrestrained Danger. And it showed that less than a majority of the school districts were actually following the guidelines, and they were following instead something that was issued by the State School Board Association, which allowed for free use of restraints and seclusion. That there was no obligation to notify parents when a restraint was used, There was no obligation to do any kind of debriefing after a restraint was used, and that restraints could be used for basically any practice that a teacher wanted to use it for. It could be used because a kid was not following instruction. It could be used because a kid was you know, destroying paper or breaking pencils or something like that, which was known as property damage at that time. So we issued this study of the disparate and inappropriate and possibly illegal practices that different school districts were doing. Go ahead, next bullet. The Commission on Youth, which is a legislative group, also did a report on seclusion and restraint, and actually drew pretty heavily on the recommendations from the coalition and drew on the information that was provided in DLCV's statewide study. And the Commission on Youth then got some legislative patrons to propose some legislation. Next bullet. Some legislation that would require the development of regulations, so that it had to, these so-called guidelines that the department had issued in 2009 were proven to be really ineffective. So the legislature passed something that required the development of regulations by the State Board of Education, and they had to comply with what's called the 15 principles that the Federal Department of Education had issued about the use of seclusion and restraint. Go ahead, next slide. Thank you. The 15 principles are things like dealt with things, thanks, no, it's okay, you can go to the next one. Dealt with things like only use it only use seclusion or restraint as a last resort. Make sure that there are practices in place for notifying parents when it's been used. Never use it for anything other than protection from harm. And so those things were all in the federal guidelines, and those were effectively required by the legislation. So next slide.
So for this, I kind of started with the legislation back in 2015, or was it it was either 2014 or 2015.
2015.
And so really how this began was connecting with the right people. So, you know, so it was first the ARC of Virginia, and this was back before Tanya and Jamie Laban was the executive director, and she helped connect us with the Virginia Commission on Youth. And then the Disability Law Center kind of got involved. And at that point, you know, the Disability Law Center's report and Commission on Youth report came out, as Colleen had said. And that's really where it went. And that's really what drove legislators to make a difference. So some of the things I did was I met with 4 dozen legislators from both parties, and I really spoke to anyone who would listen. After my meetings, I hand wrote thank you notes to all of the legislators, which really made the difference and established the personal connection. And then I established a presence on social media, and additionally, I started good relationships with advocacy organizations and other that's supposed to be self-advocates. And I think, you know, some other topics to point out, you know, is this is a very bipartisan issue in the state of Virginia, which I think is incredible. At the time that this came out, the Senate bill was introduced by, at the time, the furthest, I guess, left-leaning state senator and the furthest right-leaning state senator at that time came out and co-sponsored her bill. And so I think that really says a lot to how important this issue is. You know, and everybody worked together. I mean, this legislation passed unanimously in the Virginia House of Delegates, and it passed with 39 yeses and 1 no in the Virginia State Senate. And I just think that's really incredible. And I think, you know, we're going to talk about this later in the presentation. So all went well with the legislature. Where we really had issues was with the Virginia Department of Education.
So Alex, could you go back to that slide for just a second? I think this is a really valuable slide for everybody, because this is sort of like a little checklist of how to do important systemic advocacy. And so when you've got an issue like seclusion and restraint, or any kind of issue where you feel like you need to make some big change, I think this connection with both parties is really, really important. This really personal touch that Alex brought to it of writing the thank you notes and telling his personal story made a huge difference, I think, to so many of the legislators. Getting this social media presence, sort of getting the public on your side, or at least starting to educate the public about the importance of the issue. And then finally, the collaboration among the organizations, I think, was absolutely critical to the success of this legislation. For those of you who do things in the Virginia legislature, you know that there's sort of this rumor that a new bill, a new idea never gets passed in the first year. But this one did. The very first year it was introduced, requiring the Department of Education to develop regulations, got passed in the very first year, as Alex said, with huge margins. And it's really because of this, this great kind of advocacy procedure that Alex and others followed. So go ahead, next slide, Alex.
Yeah, and I think kind of before we go off the slide, to add to Colleen's point, you know, the organizations is really, really important, because what I've learned over the years, not just in Virginia, but even at the federal level, is that the legislators are more likely to stop and talk to a group of people with a recognizable name than to stop and talk to a single person. And so having groups behind you is definitely really important.
Right. So we're happy to tell you that finally the regulations are almost done. It took a long time, and we're going to go into some of that a little bit as we talk about it here. But just to give you sort of like the punchline at the end here, the regulations are posted on the Virginia Register, and this is the final review stage for them. Next bullet. The review period ends on August 21st, which is coming up nice and fast. And then typically under a regulatory framework, the regulations would take effect immediately. So this final review stage is just typically to let everybody kind of get their framework in place and be ready to go forward. And then last bullet, the difference with this one is that the one change that the governor made to the proposed regulations is to delay the effective date. And so these new regulations will not be effective until July 1 of 2021. And I'm sure that the governor was influenced by the disruption of schools that's going on as a result of the COVID situation. And, you know, as long as schools are virtual, teachers can't be restraining children. So I guess that's one benefit of virtual education. Next slide. Go ahead. So just as I said, we're going to get into this in a little bit more detail, but a number of things are explicitly prohibited in the new regulations. Go ahead and load this whole slide. So it's specifically prohibited to use mechanical or chemical restraints, drugs, pharmacological, I think is what the regs call them, in an educational setting. Aversive stimuli, which can be things like spraying some noxious solution or a noxious smell or something like that. Those are prohibited in public schools. Prone restraints are expressly prohibited. Prone restraints and anything that would restrict a student's breathing. And then physical restraints that are used for punishment, for convenience, for disciplinary, for failure to follow instructions, those sorts of things. Physical restraints are prohibited for those purposes, and physical restraints for the purpose of protecting property, those are prohibited. Okay, next one. So physical restraint is permitted, but under certain circumstances. First of all, you have to try everything else first. Next slide, or next bullet. The restraint has to be only for the purpose of preventing injury or harm to the student or to somebody else. Okay. A restraint can be used if a teacher feels like it's necessary to defend themselves. Next bullet. This is one of the ones that we all kind of like rolled our eyes at, and we think that this is going to be a huge loophole. But a physical restraint can be used to quell a disturbance, and I think when that language was first written into the into state law in other situations, they're talking about like an outright riot. But quelling a disturbance, we think, could probably be one of the enormous loopholes that we're going to have to be paying attention to as we go forward. Next one. Physical restraints can be used if necessary to obtain possession of controlled substances or to obtain possession of weapons. And then next one. And this is the important part here. If a physical restraint is used in any of these circumstances, the restraint has to end as soon as the danger has passed, as soon as the substances have been obtained, as soon as the risk of injury or harm has passed. Next bullet. The regulations allow for seclusion to be used, but only under limited circumstances, and we'll go into that in just a minute. And then last one. This is a really important requirement in the new regulations, and that is that parents have to be notified the same day that a restraint has been used, as much as possible, and that the principal or chief administrator has to meet with everybody involved in the incident, including the student, where possible, to debrief and see if there were other alternatives that could be pursued the next time. Okay, next slide, and I think this one's yours. Okay, go ahead.
I just to kind of add to what Colleen was saying, I think, the debriefing is really important, because what we're seeing is that, we're having kids, especially some of the parents I have worked with whose children are being restrained literally 500 times. And so I really like this because, if you're being restrained 500 times, you have to get to a point where you have to say, obviously this isn't working. What can we do that actually works? And that's absolutely important. And with the reporting, my parents were never told about my experiences with restraint seclusion. And I also think, having the restraint seclusion stop is vital, because they're, even if the danger were past, some administrators or staff still feel the need to keep the student in restraint or seclusion for, sometimes it can be up to a matter of hours.
Right. And Alex, let me just clarify something. Apparently I misspoke, but the regulations will be in effect as of January 1, 2021. Apparently I said July, so I may be just stuck in summertime or something. So, all right, take it away, Alex.
So we have restraint. So a lot of people don't know what restraint or seclusion is. So this is kind of, we're going to get into that. And so Colleen kind of hit on this earlier, as I believe. So we have three types of restraint. We have a physical restraint, which is physically holding someone. We have a mechanical restraint, which typically involves either a chair or a pad on the ground and Velcro straps. And then we have pharmacological restraints, which are drugs that can be administered either through a shot or orally, or some type of chemical sprayed. So this is an example of a physical restraint, and this is a prone restraint, which means the person who's being restrained face is in the floor. And these are the most dangerous restraints because all of the, I believe, if not all, the majority of deaths in the United States from restraint are done in prone restraint. And so then we have, this would be an example of a mechanical restraint, is the duct tape to a chair. This is obviously in Michigan, but it's not a Michigan thing. I mean, this goes on here too. It just doesn't make the headline because, I believe this teacher obviously resigned, in the state of Virginia. As of right now, that standard's not held. If you're a teacher and you duct tape a kid to a chair, you don't have to resign. You don't get fired. There's no standard. And so here's an example of a pharmacological restraint. And then we're going to talk about seclusion. So according to the regulations, seclusion is the involuntary confinement of a student alone in a room or area from which the student is physically prevented from leaving. Most seclusion rooms are typically the size of a large square walk-in closet with doors on them and a small window in the door. Now, seclusion rooms and sensory rooms are very different. I encourage sensory rooms. Sensory rooms are a calming environment in which the student enters the environment voluntarily. And the idea is for the student to obviously using different sensory types of things to calm down and then return to class. So that's very different than a seclusion room. Sometimes people have a little bit of confusion. So like I was, so in addition to a sensory room not being a seclusion room, timeout is not considered seclusion. ISS, or in-school suspension, is not considered seclusion. Detention, student requested breaks, and removal of a student for a short period of time is not considered seclusion. Now, I argue that the removal of a student for a short period of time, which is exclusion, because they're being excluded from their peers, excluded from their academics, particularly what happened to me with being locked in the hallway, but that's not a seclusion room. And so here's some additional things that are not considered seclusion: is removing a student for disruptive behavior, and removing a student for an investigation or questioning regarding a violation of the code of conduct. And there's some examples such as, a fighting incident or drugs or weapons, and sometimes even a dress code violation. So here's seclusion room versus sensory room. So sensory room is on the left, and seclusion room is on the right. In a sensory room, it's, again, voluntarily, it's completely voluntary whether you leave or whether you stay in a seclusion room. You're essentially forced to stay in the room. And so, is this you, Colleen, or is this me?
I think this is you.
Okay.
Let's see what the next slide says.
The current laws and regulations.
Uh-huh.
Oh, there we go. So
yeah.
On the federal level, the Keeping All Students Safe Act continues to be reintroduced every session, but unfortunately it's not successful. Now, the Keeping All Students Safe Act has been not as successfully bipartisan as the state level legislation, but I mean, we still have some bipartisanship. We have Dawn Beyer and Elise Stefanik working together in the House. We have Patty Murray and Marco Rubio working together in the Senate. And unfortunately, what's happening is the leadership from really both sides don't value this. And unfortunately, only things are really brought to a vote on the floor when they're considered important legislation. And unfortunately, and a lot of times people with disabilities are forgotten about when it comes to legislation, and I think that's what's happened. And I think also there's been a lack of media coverage on this. This hasn't really been reported on, which doesn't bring much attention to it. And I definitely think we could do better with the bipartisanship. You know, there's clearly some, but it's DC. And unfortunately, what happens is if I were to present a bill, for example, I was speaking with a member of Congress from West Virginia, and I was presenting her the bill, and she loved the bill, loved it. And the chief patron was Dawn Beyer, and she picked it up and she looked at me and she said, "That's a line 2 error." And I said, "What does that mean?" And she said, "That means I cannot sponsor it because he's not in my party. The party leadership will not allow me to do that." And the line 2 is the second line of the bill is the patron. And so I think, you know, and I think at some point we have to put partisan politics aside and work together to create positive change for people with disabilities and students with disabilities. So to kind of get into more of the,
before you leave that that slide, if you can just jump back, I think it's important to understand this, but I have met with members of the Virginia delegation to talk about the Keeping All Students Safe Act also. And they're really kind of waiting to hear what Virginia's experience is with the state regulations. They support the Keeping All Students Safe Act. Many of them have signed on to it, but they're really thinking that the experience that Virginia has is going to be educational to be able to promote this on the federal level.
Colleen, this is Kim Goodlow.
Hi.
Can I interject some of our questions and comments before we keep going? Is that, I just don't want to lose the place where the question was asked.
Sure. There was actually something in the chat box that I thought would relate to some points later on, but go ahead and I'll just say we'll get to that. Okay.
So Natalie Ferrero just wanted to make a comment that said, my son attends a special needs school with restraint and seclusion areas. And we had one incident last year where a teacher bruised him by pinching his nipple, clearly not an appropriate method of restraint, and nothing was done about it. I don't know if you'd want to comment on that, or
and Kim, that's a private school?
It says a special needs school.
Okay.
That's probably a private day, if I had to guess.
Yeah. And so there are different regulations that relate to private schools. And unfortunately, we are not seeing very good enforcement of those regulations. We're not seeing very good oversight from the Department of Education on that. So that's probably another serious systemic advocacy project that that organizations need to get together on.
It's Rivermont and it's owned by Centra, so I would assume it's a private school. Okay.
Right.
Robin, are you on?
I think Robin's question was one that I thought we could get to in a little bit, but go ahead.
About using restraint as a last resort?
Nope, that was not the one.
If a restraint was not used as a last resort and it was in writing by an instructional assistant, were there any consequences? See, I've lost track of where we were. I apologize.
Yeah, so it's a great question because right now, there are no requirements to use restraint as a last resort. Right now, there are no rules around that. And so schools are not obligated to hold it back until it's a last resort. It's not until these regulations take effect that rule is going to kick in. So no, there were no consequences for a school or a teacher to immediately go to restraints.
Okay, and then Richard wanted to say, hey, Alex, this is Richard Cuevas. I hope I pronounced that right, Richard, of the ARC of Virginia and an ally committee member. We would love to have you on our committee, and we need a person like you who will bring so much to the table. So Alex, we hope maybe Richard could get in touch with you and you might consider that.
Yes,
Natalie,
thank you. I believe, sorry to cut you off, Kim.
No, I'm sorry, go ahead.
At the end of the presentation, I believe Colleen and I have left contact information, so my email's up there, so if he could just send me an email,
Right,
that'd be great.
right.
And then Natalie Farrell said that she loved the fact that reporting and debriefing would be mandated, and that it's extremely important because she is rarely notified of her son's punishment or behavioral adjustment on a typical day.
Right.
Jamie Soreche, and I apologize again if I'm not saying it correctly, wanted to know, do they define weapon as a knife and a gun only, or would a chair being thrown through a window, broken glass, count as a weapon or property destruction?
So let us come to that one a little bit later on in the presentation.
Okay. And then how will this be addressed? Denise wants to know, how will this be addressed by Child Protective Services and Adult Protective Services? Are improper restraints to be reported to local DSS?
So I think that the local DSS, Child Protective Services, has the authority to do this, but there's no requirement in the regulations to report it to local DSS. I think that if a parent believes that that's going on, the parent can report it. The local Child Protective Services can investigate it, but there's no requirement that the school has to report it to Child Protective Services.
Okay, and then once again, Sean just wants to know, wants to tell Alex that as a co-chair of a Life Like Yours Advocacy Alliance, he's so proud of Alex for standing up for what is right for students with disabilities, and he wants to thank him for his leadership. And then Lynn Blythe wants to know, what is the definition or measurement of a short period of time?
So we can get to that at the end too.
Okay, and that's all I have right now. Thank you.
Okay, great. Thanks, Kim. So go ahead, Alex, I think this is yours still.
So to talk about the Keeping All Students Safe Act a little bit more. So the Keeping All Students Safe Act with seclusion actually goes further than the Virginia regulations, to where it would prohibit seclusion. And when the legislation was being written by the National Disability Rights, is it network, Colleen? It's
yes. Yeah.
Okay, yes. They found that seclusion would not be safe because it's putting up a physical barrier between staff and students, which just makes the situation so much more unsafe. So it would have very restrictive requirements regarding the use of physical restraint, and the only physical restraint, pharmacological and mechanical restraints, would be banned. It would require same-day notification to parents. It would mandate training for school personnel. And it would require annual data reporting. But this only applies to schools receiving federal dollars. They can only do this to schools receiving federal dollars. So, you know, for example, if a private school is not receiving federal dollars, they're not required to follow these. And so that's an important piece. And I believe this is yours, Colleen.
So, so first of all, we want to turn now to put the responsibility back on all of you, because there's a lot that needs to be done for these regulations to be effective. And so, so we've got a couple of slides here about things that you can do as these regulations come into effect. First of all, especially if you've got a child who might be at risk of seclusion or restraint, you should actually contact your school and just find out what their practices are. If you have a child who is going to have an IEP, one of the ways that they can get around this is by saying that you consent to seclusion and restraint in the IEP, and you just don't agree to that. You don't have to agree to that. You can make it really clear that they can only use seclusion and restraint with respect to your children as it's specified in the regulations. There's really no reason. I mean, I know that there are some really rare behavioral conditions where restraint might be the option of first choice, but for most kids, it's just never going to be necessary, except for the conditions that are set in the regulations. I think this is a great tip here, and this is Alex's here. If they've got a seclusion room, tell your school you'd like to see it. We know of stories where teachers built sort of little seclusion rooms in their classrooms by piling file cabinets up and creating a corner of a room that was blocked off from people. That would just simply be not acceptable. So, you know, ask to see your child's room, your classroom, ask to see all the places where your child might be educated, and ask to see the seclusion room. And then finally, just ask about what their practices are for contacting parents. As we said, these regs are not going to be in effect for several more months. No reason why the school can't start implementing things like parent notifications sooner than that. Next slide. Okay, go ahead.
Go to Colleen's second point. You know, a lot of school systems have been very sneaky by telling parents they're required to sign the IEP. You are not required to sign it, you know, if you don't think it's appropriate. And not signing it is actually one of the worst things you can do for a school system in terms of not put them in a very helpful place. And so often by refusing to sign it, they will want to come together very quickly to discuss what they can do to get you to sign the document.
Right. Thanks, Alex. I forgot you wanted to raise that point. I think we just need to be right out, you know, frank about this. We expect that these regulations are going to be very poorly implemented in some places. And we expect that some schools are just going to outright violate the regulations. The question that was raised about what is what's a weapon is if a kid picks up a chair and tosses it across the room, is that a weapon? You know, I think that there's so many places in these regulations where schools are going to be looking for loopholes. And that is obviously one of them. I mentioned earlier that a restraint can be used to quell a disturbance. So what does that mean? If a kid is having a temper tantrum, is that quelling a disturbance, and will they be using restraints for something like that? If a teacher gives a kid an instruction to do something and the kid you know, gets defiant about it, no way, I'm not doing that, is that going to be quelling a disturbance? We know that there's going to be violations. We also know that some school districts have gotten ahead of this. They saw the regulations as they were being developed and started training on it, started implementing their own regulations. So I think that there's going to be some places where things are good. They've gotten ahead of this, and they will have already trained their staff on other methods for responding to abnormalities in the classroom. But one of the things that you can do as we're going forward is that the Disability Law Center and other organizations like the ARC will have resources available to you as parents just to learn the details about these regulations and how to enforce them. I believe we already have a fact sheet on our website about the regulations because we've been ready for them to be issued for a long time. So we've got information available that just kind of like summarizes the details of it on our website. We're also going to be looking to do training in hotspots. So if you've got a place where you think that the seclusion is being used inappropriately, where you're still seeing restraints being used, let us know, and we will come and we'll try to train parents and train family members on how to respond to those things. We are also developing some self-advocacy tips because obviously the ARC can't be everywhere, we can't be everywhere, and so a lot of the responsibility for enforcement is going to be with the families to actually insist upon compliance with the regulations themselves. And then finally, the Disability Law Center will be able to represent some people in some cases. We're probably going to be pretty selective about that and try to find the cases that really demonstrate the loopholes that are in the regulations so that we can do that representation and then go back to the legislature to get fixes on it. Next slide. I think the next one's yours, Alex.
Okay. So these are questions to ask our school, I guess your school administrators. And so the first one is really, what are local school board and school policies? So for example, in my county in Powhatan, we don't have any school board policies regarding restraint and seclusion. Now, the difference between a policy and a practice is that a policy is there and enforceable. A practice is something that's genuinely done. So for example, I believe our special education director essentially told her administrators that they were not allowed to use restraint and seclusion in their school systems, or she told the principals that. She told them they could not use it on special education students. Now that's a practice, that's not a policy, it's not enforceable, but it's still something they do. And so knowing the difference between practice and policy is important when going down this route and learning what's a practice and what is a policy. What de-escalation strategies are in place? You know, one of the things that we like to talk about, and you know, comes up by my dad a lot, because professionally, you know, my dad is his background, his degrees are in child psychology, child development, and so this is a really big thing he hits on. Is, you know, as children aren't light switches. There's a level of buildup that's required before students have a quote unquote outburst. You know, and so we have to learn what's causing this outburst to happen and what can we do to stop it from getting to that point. Who can use restraint and seclusion? Trained staff or all staff? Is the school training staff, and are those trained staff the only ones permitted to use restraint and seclusion? For example, you know, if it's all staff, could the bookkeeper be using restraint and seclusion who has no idea what she is doing? And so that's kind of another thing, is to look at training. And most schools contract with a private company. Handle with Care and MANT tend to be the big ones in the state of Virginia. Both tend to focus on prone restraint. I would argue MANT is more dangerous because all of MANT's restraints involve 4 to 15 people. And so obviously both are dangerous. And so when can restraint and seclusion be used is another question to ask. And making sure there's some type of policy. Going back to it is not taking what you're being told to value. For example, the place where I was placed in a seclusion room for things like tearing paper and throwing markers and standing on a chair and refusing to do math homework, they told my parents that they only use restraint and seclusion in cases of imminent danger and harm to either if I'd be harming myself or others. That wasn't the case. So looking at and making sure there's a policy and not just what you're being told is really important. And then, is there a follow-up process? For example, you know, Grafton schools implemented a model called UCARU, and which is essentially a de-escalation system, so they're not using restraint and seclusion. And one of the things in their model is having a debrief meeting with the IEP team afterwards to ensure restraint and seclusion don't happen again. And this is important because restraint and seclusion is not the goal. So you have to meet and you have to talk about how can you prevent this from occurring in the future. And then you have, when are parents notified? Is it within the same week? Is it within the same school day? Is it not at all? And that's important. And just like the only for imminent danger, have it placed in the IEP that you're notified the same within 24 hours or within 2 school days, or however you want to phrase it, within the restraint or seclusion occurring, because that's important. And not only is that important, obviously, for parent communication, but if a kid comes home and begins acting distressed and upset, it's necessary for the parents to know why they might be acting like that, you know, what might have happened at school. And so that communication is essential because most children who are placed in restraints and seclusions are nonverbal. And then, you know, for people like me, I was threatened if I told my parents. And there was another point I wanted to hit on before we go to the next slide, just for a second, Colleen,
Sure.
regarding the restraint and seclusion training companies. So again, these companies, much like the private day school I talked about earlier, they tend to be financially driven, and they profit millions of dollars off of training people how to use restraints and seclusions. And so essentially, you know, they've sent out letters to attorneys. And what's corrupt at VDOE is that we have found intercommunication between a high up administrator and these restraint training companies, in which she's constantly talking to them over the phone. And then she goes into board meetings and defends their specific practices. And so it's all this method of corruption. And these restraint training companies have also sent out death threats to the governor for signing the regulations. They sent out death threats to a few advocates. And so they will stop at nothing. And it's a horrible thing, to be honest. And so we can go to the next slide.
Okay. Well, we only have a couple of minutes, and we did want to leave a little bit of time for some questions here at the end here. But just know that these regulations are a huge, great development. For the first time, there are actually some limits on what schools can do and some expectations for schools. And Disability Law Center, and I think probably the ARC and some other organizations plan to spend some of this time heading into this first semester doing training for families and educators about what these regulations require. We are absolutely, as I said, we are absolutely going to find ways that schools are violating these regulations, and we will be together seeking corrective actions, either enforcement from the Department of Education or through individual actions against the school districts, or bad publicity, or a number of different strategies that we might take. And then finally, we are relatively sure that some additional legislation is going to be necessary to close some of these loopholes. We've already had conversations with legislators about supporting us in that. Our focus right now has been getting these regulations ready to go, getting them out, and sort of recognizing that they are imperfect, but they are so much better than what we had before that. And I think that leaves us only about 6 minutes for questions.
Colleen, this is Kim Goodlow again. I have a couple of questions here. I have 2 questions about the funding, and Lynn and Bradford Holter want to know, if private schools receive CSA and FAP funding, would that be considered receiving federal funding?
I don't know, I actually don't know the source of those funds, but I think that there are probably not very many private schools that don't get any kind of public funding at all.
Typically, the private day schools,
And I think,
Tanya, they're getting the CSA funds, and so that is state funded,
Okay.
and theirs is 100% CSA funds. So I don't know if that helps to answer.
Yeah,
that.
so Tanya, the question goes to the keeping all students safe requirement, that federal law would only apply if the school is receiving federal dollars. And I don't actually know whether CSA funds start out as federal dollars or FAPT funds start out as federal dollars. You know, if it's the state of Virginia, I'll bet you there's some federal dollars in there somewhere.
Okay. Okay.
And then Karen Gregory stated that some schools and facilities are stating that parents can't see seclusion areas due to confidentiality of other attendees.
Well, they probably shouldn't see the seclusion and restraint, or the seclusion rooms while there is a children in it. And if that school district cannot make that room available to a parent to see it because there's always a child in it, that's probably something we need to know about. Department of Education needs to know about it. We need to know about it. The ARC needs to know about it.
Right, and one parent did say that she went in to see it during a weekend training date as a recommendation to others that on a Saturday morning. So maybe that might be something that other parents could do.
Right.
And then Denise says she has concerns that schools will increase their requests for law enforcement response as a get around to the new regulations.
Yeah, and that's absolutely one of the
Um,
things that we're concerned about as well. The Legal Aid Justice Center got some changes through in the last legislative session to limit law enforcement involvement in school activities. And we expect that there's going to be more changes as part of the police reform efforts, but that's absolutely one of the things that we want to watch for too. Alex, were you going to say something?
Yeah, to add to that is, I'm not sure, maybe you could answer this, Colleen, but it's to my understanding that SROs are not necessarily required to follow these regulations, correct? They follow the regulations of their department.
I don't remember that. I would have to look at that to make sure that that's true, but that might be true.
Okay, and our last question from Lily is there a training group you would recommend to train school staff on how to do it properly?
So the State Department of Education offered some resources to every school district, and I think every region finally did accept that offer. So there's been some funding and some resources made available to the schools to get appropriate training on that. I certainly wouldn't be in a position to endorse one particular organization over another. And Alex, I don't know whether you feel like you would or not.
Yeah, I think, you know, I'm not familiar with all the organizations, but I would recommend UCARU. Just that's kind of the one that comes to mind. You know, the school system, the school they were implemented in went from thousands of restraints a year to less than 10. So they're definitely made progress. And essentially they use a comfort over control model, meaning that their idea is behind comfort. And I mean, you know, if you send me an email on the screen, I can connect you with Kim Sanders, their president. But I mean, you know, there might be other organizations out there that I'm not aware of, but I know to add to that, Kim has been involved with the Keeping All Students Safe Act. So, you know, they're definitely good people trying to, you know, eliminate the use of restraint and seclusion while keeping everyone safe.
So we're at the 10 o'clock, 11 o'clock hour. I just want to remind everybody on the webinar that to get this contact information, and we will post this presentation on our convention website. And I really just want to thank Alex and Colleen, and you know, for all you're doing, all the information, for presenting here today. And Alex, I want to thank you for taking leadership of this and, you know, really kind of waking up Virginia to these horrible facts and helping us change that. So thank you for that.
Kim, can I get one last plug in?
Absolutely.
So in this last slide here, you know, we're encouraging people to become volunteers at the Disability Law Center. And we are specifically trying to develop a trained core of parents and family members who can assist others in IEPs and especially in responding to seclusion and restraint. So I encourage you to get on our website, look at the volunteer page, and if that's something that you'd be interested in, we would really welcome your help. Thank you.
All right. Well,
Yeah.
thank you all
And
very
I
much.
wanted to thank Kim and Tanya for having us, and thank you, Colleen, for being here.
And Alex, thank you for your advocacy on this and for your patience with me as we developed this technology together.
It's a learning process, Colleen. I feel your pain.
For all of us, for all of us.
What we have found is most of our alliance advocates are helping us maneuver all this technology. They seem to be the experts in this area. So
right.
They're getting lots of practice. We all are, aren't we?
Yep.
Thank you. Bye,
Thanks,
everybody.
Bye-bye.
Have a great day. We'll
Bye.
see you later at the convention.
Right. Bye-bye, everybody.